firstly then, not going to say too much about ASTs because I'm sure that we're probably quite familiar with what they are or what we're dealing with. But just by way of reminder, of course, any residential tenancy created after the early part of '97 will be an AST unless the landlord has served a notice saying that the tenancy won't be an AST. Prior to then, when ASTs came in, the situation was you wouldn't create an AST unless you served notice to say that it would be an AST. But that was flipped from February '97. We'll also know that there have been quite a few reforms that have come in the last few years. And we'll also know that there are reforms on the horizon. And I think that's been the subject of a separate talk, so I won't say too much about that. But a big shift or a big change, of course, came in by virtue of the Deregulation Act, which brought in some changes to the way ASTs can be brought to an end, and I'll touch upon that briefly later. We've also got the Tenant Fees Act, which restrict payments that can be required to be paid from tenants. So they're two quite substantial bits of legislation that are relevant to ASTs. Of course, we also have assured tenancies, and an AST is a type of assured tenancy. An assured tenancy has much greater security of tenure, and in the private residential sphere, of course, the tenancy that's used is almost exclusively assured short-hold tenancies. Property can also be let under a contractual tenancy, and that will happen, for example, where the rent is under the prescribed figure. And also, you can't grant an AST, of course, to a corporate entity. So if you do a corporate let, that will be a contractual tenancy rather than an AST. So then, moving on to termination of ASTs, one of the major points that hopefully we don't need to remind anybody about too much is that as a landlord, you can't evict your tenants without a court order. If you do so, you're going to be offending the provisions of the Protection from Eviction Act. An unlawful eviction can give rise to both, it was a criminal wrong, it's a criminal offence, and is also a civil wrong as well, so can leave you open to claims for damages, which can be quite substantial, and also an injunction to allow the tenant to come back into the property following an unlawful eviction. So if you're thinking about it, don't do it, seek advice, get a court order. Of course, it's expensive, or it can be expensive, but it's a lot cheaper in the short run. There are two different procedures for terminating ASTs. So as mentioned earlier, you've got the Section 8 route and the Section 21 route. You can serve both notices, and in many instances that you may conclude where you can serve a Section 21 notice and there are also breaches that can be relied upon. You might serve both, and that is a decision that I've seen taken in quite a few instances, and it's a decision that you take depending on the circumstances of that particular case. There are some issues, though, that may arise if you elected to serve two notices at the same time. You might be faced with a tenant and say, I'm not really sure about what's going on here. I'm slightly confused. You've given me two notices. What do you want me to do? Because, of course, you've got two notices that have got differing or potentially have differing dates by which possession is required. If you also serve two notices, you might have, or you might end up with issuing two sets of proceedings. One set of proceedings of course, arising from the fact that you're entitled to possession under Section 21, and one set of proceedings that relate to, say, breaches of the tenancy agreement. I have had that in a couple of occasions where we've actually issued two sets of proceedings that have been consolidated. It can be done, but there can also be some procedural issues that arise. Another observation is that courts might not be too sympathetic when you've got two sets of claims that are on the go, where you've got the same cause of action. I suppose the cause of action is slightly different, but ultimately we're talking about obtaining possession of property. Again, I don't think I've seen that in practice, but that's certainly something that you might want to keep in mind. So, just moving, or before moving on to the specifics of each notice, just a couple of, or a few wayside remarks. There can be advantages for serving a Section 8 notice on the grounds of tenant default because, for example, the notice periods are shorter. In some instances, the notice period you have to give in a Section 8 notice is a couple of weeks. If there are substantial arrears and there's no prospect of the tenant discharging all of those arrears, then it may provide you with a quicker route to obtaining possession. Of course, alternatively, as we all know, whilst they're still around, get them whilst you can. Section 21 notice doesn't require default. So it doesn't depend on whether the tenant, for example, has breached the terms of the tenancy agreement. But as I will touch upon later, you've got to get your procedure right as well. And it's not uncommon for landlords to get into difficulty because they haven't complied with the obligations that are imposed upon them by the Deregulation Act. When they come to serve a Section 21 notice, you often, or it's not uncommon to find, or to be in a situation where you've decided, right, okay, I want to serve a Section 21 notice. That's hunky-dory. I don't need to give them a reason for possession. But when you look back and carry out a bit of an audit trail exercise, you realise that you haven't complied with the statutory requirements, which then can prevent you from serving a Section 21 notice, or you've got to jump through additional hoops to remedy the failure to comply with the process before you can serve that notice. If you can serve a Section 21 notice, of course, we know that there are two routes or two types of proceedings that can be brought in order to get possession if the tenant fails to comply with the notice and vacate. We've got the accelerated possession procedure, and then we've got what we typically call the standard possession procedure. Now, the accelerated procedure, as we know, is carried out essentially on paper. You've got to have got your paperwork in order. Your paperwork's appended to the claim form. The tenant has an opportunity to respond to the claim. The evidence or the paperwork then goes to a district judge who looks at everything, and if everything's in order, will give you possession. Now, a hearing can be ordered in certain circumstances, notably if the tenant is asking the court to suspend the date of possession, and essentially to give them more time before they vacate. So there can be a hearing in those circumstances, unless you indicate on the claim form that you're quite content for the matter to be dealt with on paper. Now, the downside, although the accelerated possession procedure is dealt with on paper and is often quicker, the downside, of course, is that you can only seek possession. So if there are arrears, you've got to bring a separate claim for the rent arrears. Whereas if you bring a standard possession claim, you can seek possession and you can also seek the arrears as well. So those are often issues that need to be weighed up and taken into consideration when you make a decision as to which route to take. I'm also at this point going to say something very briefly about abandoned premises. This often comes up. You might have a scenario where a landlord approaches one of my colleagues and says, well, property's let under an AST, not seen the tenant around for a while, or I don't think I've seen them around for a while. I've mooched around at the property and I don't think they're there. I've had a look through the window. It looks like there's not been much activity for a while. The place has been abandoned. I can just go back in, can't I? And just take the property back. The difficulty with that, of course, is you can't always be sure that the tenant has actually abandoned the property. A surrender can arise by operation of law. So if the tenant abandons the premises or moves out and gives you the keys for the premises, then you can accept that offer to surrender by going in, retaking possession, and that would certainly constitute a surrender by operation of law. But it's very difficult to conclude that a tenant has abandoned the premises just because they've not been there for a while, or it looks a little bit empty. Because of course the obvious point is, and we, over the years seen this, tenant might be on a long holiday to New Zealand, and they haven't abandoned the property, they're just on holiday. They might be in hospital. There might be a scenario where they've been quite ill for a while. So that clearly explains why they haven't been there. You retake possession, shortly afterward, tenant reappears and says, oh, what are you doing here? You're then on the receiving end of an unlawful eviction claim, which, as I mentioned earlier, is both a criminal offence and also gives rise to quite substantial civil remedies, so damages and injunction. And then, of course, you'd also be responsible for the tenant's legal costs for pursuing the claim. And again, speaking from experience, not personal experience, but professional experience, the liability can be quite substantial. So I think the advice has always got to be safety first, and don't just assume. And I know there are websites that talk about abandonment notices and that kind of thing. I think I would always caution or advise clients to exercise caution in those circumstances, and as I say, exercise safety first. So of course, consider whether you could serve a Section 8 notice or a Section 21 notice, and you could serve both, and you could serve them without prejudice to the other. The other route might be to serve a notice to quit, which is a different type of notice, which is neither Section 8 notice nor Section 21 notice. If the tenant is no longer essentially living there as their home, so if it's no longer their principal residence, the tenancy is no longer an assured tenancy. So in those circumstances, you could serve them with a notice to quit. So again, I think many years ago, I had a situation where the tenant hadn't been seen for a while, and that's because they were detained at Her Majesty's pleasure for quite a substantial period of time, and we served an NTQ and then obtained possession that way. So, as I say, would counsel caution in those circumstances, and just kind of pause and think and seek advice as appropriate, and don't always go with the gut and conclude that the property's been abandoned and we can just take it back, because the penalties, as I say, could be quite severe. Before talking about Section 21 notices, I'm just going to say a few things about Section 8 notices. Now, as I've said earlier, Section 8 notice is the type of notice typically that you give a tenant where they're in breach of their obligations. There are a number of grounds under which you can seek possession or eviction from the premises. And the notice period that you give depends upon the ground that's relied upon. Now, I've briefly touched upon in the first bullet point, during the pandemic, and I said I wouldn't say too much about this, but during the pandemic, the periods were amended to give tenants, obviously breathing space, time during what was, of course, a very uncertain time. Since the 1st of October 21, though, we've reverted back to the pre-pandemic position. So the notice periods for Section 8 notices are as you were. If you're not familiar with the various grounds for possession that can be relied upon, you can find those in Schedule 2 of the Housing Act 1988. I'm not going to go into those in too much detail to keep this informative webinar short. But one thing I would say, they have a shelf life of 12 months. So if they are served, you can't rely on it after a period of 12 months has elapsed. Now, in seeking possession under Section 8 grounds, we have mandatory grounds and we have discretionary grounds. Some of the grounds also require prior notice. So if you have a look, I'll call them grounds 1 to 5. You have to give the tenant prior notice to say, well, okay, we're entering into this tenancy agreement, but just to let you know, if the circumstances arise, I intend to rely on, a ground, for example, if you intend to reoccupy the property, then that would be one instance. Now, ground 8 is the one that's commonly relied upon, and that's there being, so if the rent's paid monthly, there being 2 months arrears outstanding at the date of service of the notice and the date of the possession hearing, you've only got to give 2 weeks, or the notice has to specify you've got 2 weeks to sort it out, otherwise we're going to bring possession proceedings. There is a recent wrinkle. So I said that there have been various reforms over the years, and I touched upon the Deregulation Act and the Tenant Fees Act. We've also got the Debt Respite, and I will say that correctly because that's quite difficult to say, Debt Respite Scheme Regulations. And this relates to debt, and essentially it's a new scheme where a debtor can seek a breathing space moratorium or a mental health moratorium. So there's an additional process whereby a debtor can secure protection or some additional time from being pursued for their liabilities. Now, insofar as we're talking about proceedings that relate to rent arrears, you can be prevented from serving a Section 8 notice, as I've said in the slide, starting proceedings, or depending where you are in the process, enforcing a possession order where the tenant obtains one of these breathing space or mental health moratoriums. So just something to keep in mind. You would get notice of that, I think, from the insolvency service. But if you do get notice, as I say, it does have a temporary impact upon your ability to recover the arrears, pursue the arrears, and take steps to recover possession of the property. My understanding is it doesn't relate to liabilities that accrue during the moratorium, so they should still be paying you rent in the meantime under the terms of the tenancy agreement. So as I said, the grounds of possession that you can rely on, you've got mandatory grounds and you've got discretionary grounds. Now, what does that mean? Well, of course, mandatory essentially means that if you can prove to the court that the mandatory ground applies, so ground 8, 2 months arrears outstanding at date of service of notice and date of hearing, then the court must make an order of possession. There's no discretion, it's mandatory. And that also impacts upon the court's ability to postpone the order for possession. And as I've said on the slide, it's 14 days, or the usual order, of course, is 14 days or possession in 14 days, but it can be postponed for up to 6 weeks in cases of exceptional hardship. And that would be down to the court to decide what constitutes exceptional hardship in that case. In contrast, discretionary grounds, so if you can show that a discretionary ground applies, then the court can make an order for possession, but doesn't have to. So, for example, if you're dealing with rent arrears, you'll serve a notice to say, I'm relying on grounds 8, 10, and 11. So that would be, you would also be relying on the ground that the tenant, there have been rent arrears at any time, or rent arrears have accrued during the course of the tenancy. Well, that would be a discretionary ground. So it would be for the court to decide, if the tenant's conduct or payment history has been such that the court should exercise its discretion to make a possession order, then it will do so. But as I suspect we often find, district judges are not always, if there can be a reason for not evicting somebody from their home, you quite often find that district judges will find a reason not to make a possession order. If a possession order is made on a discretionary ground, then again, usually it's possession in 14 days, but the court can stay or suspend the order for such period as it considers fit, or can grant a postponed date for possession for such period as it thinks fit. So the court does have quite wide powers when it comes to discretionary grounds. So moving on to section 21 notices, again, as I alluded to earlier, we were on shifting sands during the course of the pandemic. The notice period was amended several times during that period, again, to give residential tenants some breathing space or protection from losing their home during that time. But again, from October 21, the minimum notice period has gone back to 2 months. Now, there is a prescribed form, the form 6A, and that is the form that should be used, and you should make sure it does get updated periodically, and the correct form should be used at the particular time. After the 1st of October, these things, or these notices, have a shelf life, to use that phrase again, of 6 months. So they're only valid for 6 months from the date on which that notice has been given. But there can be circumstances, if it's a periodic tenancy, certain periodic tenancies, you might need to give more than 2 months notice. And in those circumstances, you get more time, and you get more time it's 4 months, I think, from the date in question. So in the vast majority of cases, your notice is going to have a shelf life of 6 months. Now, I'll come on to the deregulation requirements, or Deregulation Act requirements, but just one point to make is section 21 notice can't be served within 4 months of the day on which the tenancy began, or if it's a replacement tenancy, 4 months of the day on which the original tenancy began. So that's just something to bear in mind when considering the validity of the notice that you may have given. So just saying something about the Deregulation Act requirements and their impact on the validity of a notice. And I've distilled this quite substantially, just to give you the key points for information purposes only, of course. As I've said on the slide, essentially from October 15, although of course the deposit or the tenancy deposit scheme has been in since what, 2007. But essentially, to ensure that your Section 21 notice is valid, you should ensure that the deposit, if one has been taken, is in a tenancy deposit scheme, and you've given the tenant the prescribed information in relation to that tenancy deposit. You should be giving your tenants if there is gas, of course, a gas safety certificate. Now, there has been case law on giving the tenants, giving the safety certificate late, because it was thought at one time that if you didn't give it, then that would prevent you from serving the Section 21 notice. But of course, there was recent case law that says as long as you've got one for the start of the tenancy and subsequently, if it was just an oversight that you didn't give it at the time, then you can remedy that by providing it subsequently. But of course, good practice is to give the gas safety certificate before entering into the tenancy. You've also got your EPC as well, your energy performance certificate. You've got your how to rent guide, and that can sometimes throw up some issues. And I say that because if you didn't give it before the start of the tenancy and you're looking to rectify the position afterwards, this how to rent guide, as you probably know, has been updated over time. And there have been a number of versions in existence. So you need to ensure, if you're doing it retrospectively, to use the version that was in force at the time the tenancy agreement was entered into. If you do think you've got a problem, or if having done the audit trail prior to the service of a Section 21 notice, you've looked at it and thought, yeah, okay, I may not have done this. I don't think I've done that. I think I've got a problem with whatever. Again, it's probably worth seeking advice from a professional dealing with residential tenancy matters, just to look at whether that impacts upon your ability to serve the notice at all, and then secondly, whether you can rectify it. Just in relation to other issues that as well can impact upon the service of a Section 21 notice, you can have problems if you've taken a deposit over 5 weeks' rent, or you've taken a band fee. You can also have a problem if you need an HMO license. If you don't have an HMO license where that's required, that impacts upon the validity of a Section 21 notice. Also, where you've been ordered to carry out repairs under an improvement notice or an emergency works notice, or if that's come through from the local authority. And then, of course, the tenant could also make written complaints. So in the press, we all know that there was a big hoo-ha about retaliatory evictions, tenants raising complaints about the state and condition of the property, and then very shortly afterwards being on the receiving end of a Section 21 notice saying, well, okay, I'm giving you 2 months notice to go. And you just need to be mindful if a written complaint has been given and how you've dealt with that written complaint following receipt. I'm now going to just say something about service of notices, because service can be an issue when you're dealing with the service of any property notices. So not necessarily notices to terminate assured short-hold tenancies. Lawyers, landlords, professionals, whoever, have sometimes got into difficulty by not correctly or effectively arranging or dealing with service of the notice in question. So this issue arises or can arise in relation to business tenancies, for example. It can arise in relation to break notices, for example, again in the sphere of commercial leases and tenancies. Service is important because, of course, you've got to show that the recipient of that notice has had it, and they've received it, because, of course, if the tenant hasn't received the notice, or if you can't establish that they've had it, then it's a fairly easy defence to say, never had it, Gov, didn't reach me. So it is something to ensure, of course, that you get right. Now, the first thing to say is that the tenancy agreement might say something about service. It may prescribe how service is to be effective. It may, or affected. It may say that a notice will be deemed served in certain circumstances. So the first port of call, as I say, would be to check the tenancy agreement to see what it says, and comply with the requirements of the tenancy agreement. Tenancy agreements quite commonly incorporate Section 196 of the Law of Property Act 1925. So, and that's a provision, or a deeming provision, when it comes to the service of notices. And again, I've distilled it in the slide that's on my screen. And essentially, a notice will be sufficiently served if it's left at the last known place, or place of abode or business of the tenant or the other party, or if it's sent but not returned. So the not returned is the quite important part, by recorded delivery, and recorded delivery also includes special delivery. So it's quite common where the tenancy agreement incorporates Section 196 to send by first-class post, but of course you can't prove that the tenants received the notice by first-class post. I know, there's reference, for example, to the civil procedure rules where something is deemed served 2 working days after posting, but we're talking about service of a property notice instead here. And if you just committed it to the first-class post, you've got no proof unless they acknowledge receipt and sign a copy and send it back to you. You can't prove that they've received it. Similarly, relying on the deemed provisions or the deeming provisions, that if you send it by recorded delivery, they will have had it. So as I say in the next slide, they would have had it in the ordinary course of post. If it comes back undelivered, then again, you can't prove that that they've had it. Okay, if they've signed for the recorded delivery or the special delivery letter, you'll have the evidence via the Royal Mail to establish that it was received. So you just need to take those issues into account. Now, under the common law, so leaving the provisions of Section 196 of the Law of Property Act to one side, under the common law, you've got to show that the tenant had knowledge of the notice before the period mentioned in the notice is commenced. As I've said earlier, you've really got to show that they've had it. So what else can you do? Well, you could actually go to the property and get somebody, knock on the door and physically hand it to the tenant, and make a contemporaneous statement saying what you did and how you did it. You could do that yourself, but it would be advisable to take a witness with you, so somebody who hasn't got skin in the game, so to speak, to make a statement as well, to say, well, I was with Mr. X, I saw Mr. or Mrs. X, of course, hand deliver or hand the notice, or hand an envelope containing the notice to Mrs. T, the tenant. And that was done on the 26th of July at 5 p.m. The sun was shining, and there wasn't a cloud in the sky. Alternatively, of course, it's an additional expense, but to get a process server to do it. So you get somebody, an individual who deals with the service of legal documents, proceedings, etc. Pay them you know, 70, 80 pounds plus VAT. They haven't got skin in the game. They go and personally serve it on the tenant. You might also, for example, if you're going to do it yourself, take a photo of you putting it through the letterbox. That may or may not be an idea. But service is important. And as I say, we have had over the years cases where the tenant has said, well, I never received the notice. Landlord says, well, I put it in the post. I sent it first class post. And isn't it deemed to be received 2 days later? And the tenant says, well, no, I didn't receive it. That's going to cause you a problem when it comes to your possession claim and seeking possession from the tenant. That's really it from me. Hopefully, some of you have found that informative, and I thank you for your time, and I'll hand back to our host.
Hello, thank you, Jonathan. That was fantastic. I learned bits on that as well, so that's great that we've both done that as well. So I'm just going to stop screen sharing so we can have a bit of, there we go, Q&A. So I know we've had a question come in, Jonathan. So everybody, there should be a chat box at the bottom of your Zoom screen. Debbie's put a question there, which I'll ask Jonathan in a second. So if you've got any further questions, we've got sort of 15 minutes to go through as many as possible. I've had a few in email as well. So we're trying rack Jonathan's brain for the next 15 minutes as much as possible. So you probably just about answered this one already, Jonathan, but Debbie just wanted to ask, could you photograph or video the delivery of a notice? Which I know you said yes. My sort of question would be, where do you think an acceptable photo? Because if you're just taking a photo of a letterbox with a notice being pushed in it, that could be any letterbox. So what would you advise in that case?
Yeah, I mean, look, that's a practical suggestion. I haven't had it tested in a particular court case, but I suppose if you can show that it is the front door of 22 Acacia Avenue in some way, then I don't think that hurts.
Yeah.
Of course, you do sometimes get into issues where you've got communal areas. So you've got a block of flats, for example, and in fact, I had a situation a few weeks ago where we decided to, it was a nice sunny day, it was just down the road, and I went over to the property to go and hand deliver something, and you had to buzz in through the intercom. Well, the relationship was such that I didn't really want to buzz on the intercom to get access to then get to their letterbox. Now, if there's a communal, there was a case, I think in the 60s, I'm going from memory now, that said if you deliver it to a communal post box, then that would be sufficient if there is a communal post box. But of course, if it's intercom controlled, and then each flat's got their own individual letterbox, then as I say, it was an issue for me, being the lawyer. I was hoping I could get access and put it through the letterbox, but that didn't happen at that time, so I had to go away with my tail between my legs and take a different route. So as I say, have I had a situation where that's come up in court and that's been a piece of evidence that's been central to whether we could show that service had been affected? No. I don't think it hurts. I suppose taking video.
Yeah, video might be a better option, mightn't it?
Yeah, I mean, you're
walking up the garden path with your video.
You might. Not really my area, but taking video, I wonder whether you would then, when you're off the, for example, if you've gone up the garden path, I know you don't have an expectation of privacy in public. I suppose that would just be something to think about if you then started videoing. If the tenant comes to the door, for example, and you're videoing them, and you're videoing the interaction, that may be something that you might want to consider. But again, it's just, so I would say, of course, the best position would be to get a process server to do it, because they're a third party. I appreciate that's an additional cost. If you're going to do it yourself, take somebody with you. You know, that should be sufficient, because at the end of the day, you're going to have to make a witness statement. I know people often use so for the civil procedure rules, you have the certificate of service. And I know that people often use that, don't always use that, quite often do a separate statement of service. But either way, you're going to be confirming essentially akin to evidence on oath that you've done what you've said you've done. And, you know, if you haven't done it, then there are potential consequences for you.
Okay, perfect. Giles asked, which I think you answered as well, is it acceptable for the process server to put it through the letterbox and reduce this as a signed statement? Is that what a process server would do then? Is that how they serve it?
Yeah, so under section 196, it's deemed served if you leave it at the place of abode.
Okay.
My understanding, the times that we instruct them, they will, I think their starting position will be to hand it to them. But if they are unable to hand it, then I think they'd put it through the letterbox. And of course, as I say, if section 196 applies, then it is deemed served if you leave it at the last, you know, abode. You can also affix the notice to the property as well. So that's also permitted, of course, whether you want to do, you know, put up a notice on the outside of the property with your contact details and everything else. You might, you know, decide against that. But yeah.
Perfect. So I've had a few questions in, so we're going to keep you busy, Jonathan. I thought my AST stated that a tenant must inform me if they are leaving the premises unattended for a couple of weeks. And most tenancies do say over 14 days, don't they? Have I remembered it wrong? No, you haven't. If it's one of our tenants agreements, it does say that. Or would I be correct in thinking basically that would cover a tenant seeming to have vacated? So I think they're obviously going back to abandonment here. So if there's a clause in the tenants agreement saying they must notify the landlord or agent if they're vacate, but I suppose they can't if they're in hospital and
exactly.
necessarily.
And the law of abandonment, of course, is you've made a positive decision to give that thing up. If you see where I'm coming from, and you know, elsewhere in the sphere of property law, so if you're talking about easements, for example, non-use of an easement for about 170 years, I seem to recall, didn't constitute abandonment. So yeah, I don't think you can say, because bearing in mind probably that's in a dusty corner of the tenancy agreement the tenant hasn't read anyway.
Would that class as a breach of tenancy? Could you go down Section 8 on that basis?
You could, I suppose you could, but then it would be a discretionary ground, and I don't think you're going to get possession. Nice try, and if you want to try it, fine. You know, be my guest, but I wouldn't advise it.
Okay. Next question I've got here from Elizabeth. You've talked about evictions for non-payment of rent, but what about tenants who are slowly demolishing your property? Like someone playing football in the tiny back garden, damaging the fencing, the outside light, and the gas flue on the wall. That's excluding the damage inside the property. So obviously a landlord here that's got a tenant causing damage to her property. What would be the route for her?
Yeah, I mean, I suppose the first issue would be, you know, what damage is being caused to the property. I mean, are we talking substantial damage? Are we talking about you know, kind of superficial stuff, or you know, but potentially again, you know, it is a route to possession, and I think in each case the court's going to consider, you know, what type of damage or what extent of damage are we dealing with. So it would depend on the individual case, I think, is the answer to that.
Yeah, Okay, and that would probably be under a discretionary ground as well, wouldn't it, depending on the evidence you can provide?
Yeah.
So I know evidence bits, so that can be fun. Another question you've had in here, in terms of abandonment, what if they've removed all of their furniture, i.e. the house is empty? So if you've gone, I suppose you've gone to property, the house is empty, how would you regain possession?
As I've said before, that may well indicate that they've gone. But if you haven't had the keys back, I suppose all I'm saying is this: it's not outside the realms of possibility that the tenant is going to say, I haven't abandoned the property, I haven't surrendered the tenancy. Yes, I moved my stuff out briefly. We've seen all manner of excuses. It's whether you want to take the risk. In each case, you have to make a decision, I suppose, as to whether, on the kind of facts as you see them, are you prepared to take the risk of potentially it being an unlawful eviction? So I don't think you can't do a kind of a chart to say no table and chairs or fine, bed left behind not fine. It's going to depend on each case and what you find. And all I'm saying is you may find that the tenant then comes up with an explanation to say, well, okay, you may have found the property like this at that time, but there's a reason for that, and the reason for that is as follows. I don't know, I was getting the carpets cleaned, so I had to move everything out to get the carpets cleaned. So it's really, I suppose, stop and think, and as appropriate, seek advice. And I'm not saying that to sell legal services, but just to seek advice from a letting agent or whoever to provide an additional view on it because of the the consequences.
Perfect. So another question I've had: if I take my tenant to court to regain possession, am I able to claim back the court costs from those tenants?
Well, the situation, I think, is really this. If the claim isn't defended or disputed, then you're only going to get fixed costs. So under CPR 45(5), I think it is, you're entitled to fixed costs on issuing the claim. It's about 70 odd quid, I think. Then you're entitled to some additional costs on entering judgment of about 51. We're talking about, say, rent arrears cases here. So if you get possession, there's no defence, there's no challenge, you're only going to get fixed costs. If the claim's defended, then you should be able to look to get some costs under the kind of usual jurisdiction of the court to award costs to the successful party. Now, there is an additional argument in that if your tenancy agreement contains a cost recovery clause, then you can look to recover some costs under the contractual obligation to pay some of your costs in certain circumstances. But again, I would say it's a situation where the claim is disputed or challenged. Of course, in relation to accelerated possession proceedings, then you are only going to get fixed costs. But in a default situation, it will depend on whether the tenant, as I say, has kicked up a stink, defended the claim, and it's not been disposed of, at the first hearing without any challenge.
Perfect. Got another one. My tenants moved into the property before 2015. Do I still use Form 6A to serve notice because I haven't served them the EPC or the gas safety as it didn't apply?
So you have to use this Form 6A in all instances, my understanding is that since the 1st of October 18, you should be using the 6A. So regardless of whether the tenancy was entered into in 2015, before then, whatever it might be, you should be using the current form.
What should the landlord do about the gas safety, the EPC, etc.? Should they serve that with the notice, or how around that?
Yeah, good question.
Only because I've had one of these recently, Jonathan.
All right, brilliant. Right, okay. My understanding is that if you're talking about the EPC and you're talking about the gas safety certificate, then for the purposes of serving a Section 21 notice, the provisions under the Deregulation Act don't apply when the tenancy was granted before the 1st of October 2015. So if you're talking about the gas safety certificate and the EPC, then I think you're okay. And there was a recent case on EPCs, wasn't there? Minster and Hathaway, something like that. There's been a case in the last year, certainly in relation to EPCs. You've also got your how to rent booklet, and I mean, I would probably say best practice, just to avoid any difficulty, I'd probably just give them anyway, and dish everything up before the start of the, before you give the notice. I recall, I mean, it's quite a long time ago now, but when the Deregulation Act came in, the provision said, didn't they, that it applies to all tenancies from the 1st of October 2018. And we had instances where even for kind of quite elderly ASTs, we were just serving everything and giving everything to the tenants before that date, because there was a load of uncertainty as to how it was going to work and how it applied. So certainly insofar as you're dealing with the EPC and the gas safety certificate, I think you're okay, but I think the advice probably most people would give is just give it anyway. And of course also, you've got an issue of you not, in that if you're going to use the accelerated possession claim, then the claim form requires you to insert on the form that you've given all that information. And I think you can butcher it. I think we've kind of changed or written certain bits on the form, but if you've given it, albeit subsequently, at least you can complete the form to say that those things have been given, if that makes sense. So yeah, that's what I would say about that.
Lovely. So we were 5 minutes late, so we've got 2 minutes left. The last question, which I've been asked a lot of, and this is a stab in the dark, I suppose it's a question more from me, Jonathan.
Yeah.
So what are your views on the establishment of the Section 21 notice? Is it going to help landlords regain possession of the property, or is it going to hinder?
Well, on the face of it, it's probably going to hinder, because of course you haven't got that no fault ground to rely on. I suppose a lot will depend on the ultimate detail. I seem to recall that the government said that they're going to strengthen the Section 8 grounds. I'm not entirely sure what strengthen means, but it's going to help landlords to get their property back when there's a breach. I think there's also going to be a provision, isn't there, that if you want to come to sell, then, but I think you have to give, I think, some evidence to,
You haven't said what yet, but
and I also understand, and maybe I should have studied the provisions a bit more, but there'd be transitional provisions, but ultimately everything's going to go periodic. So it'll be periodic. Tenant can give 2 months notice, and it will just continue as you are unless the tenant gives their 2 months notice, or you look to while the the grounds. I think I saw some stats. I'm not quite sure how accurate the stats are. I can't remember where I saw them, so that's not really helpful at all. but I think that most cases where a landlord's seeking possession, are not actually Section 21 cases anyway. I think most possession claims arise because of tenant default, and I don't think it is quite the situation that, you know, private residential landlords are just using Section 21 notices on a whim, as is often presented. So will it make it more difficult? Well, yes, as I say, it depends on the detail, but if my recollection of these stats are right, well, then it's not going to change things too much, because it's not usually where, you know, where these are pursued, it's not the primary reason or route for getting possession. You know, there are other reasons. Normally, tenants being in default, they haven't paid the rent, you know, they've been tearing the place up, whatever it might be. So, or there's antisocial behaviour, you know, so who knows? But as I say, on the face of it, it's tempting to say, well, if you lose the no fault ground, then it is going to make it more difficult.
Yeah, true. We'll see what they do with reforming the Section 8. That's going to be the interesting part. Well, we've gone 1 minute over, so I think that's absolutely fine. But thank you, Jonathan, so much for your time this evening.
Thank you.
I think we've all learned a lot. I will be, again, we've recorded this evening, so we will be sending that out to everybody that made it and was on the list who couldn't make it, because I know some did say that they couldn't make it, but would, you know, on the list, so they got the email of the recording. And I'll send out Jonathan's contact details within that email as well. If anybody else does need any assistance or has any queries, you've got Jonathan's number there to give him a call. So we'll let you all enjoy the rest of your evening. Thank you very much. And thank you again to Jonathan for joining us and providing that presentation. Right, have a good evening all. Thank you. Bye.
Bye.